So there's a couple of things first. There's three things I want to say up front, and then I want to take you through a very small amount of history about the Australian context, and then the principles that I have drawn that might be useful for you to consider to start your conversation. The three key things I want to say is this. It is a whole of economy issue, and therefore it requires a whole of economy response and broad input from everyone about this. So this matter the principles of the court, in my view, will be set in the context of this matter, but they are likely to be influential beyond that point. And I think, therefore, there is a need to have a broad conversation about the principles, I think, and hopefully a whole of union movement response to it, and hopefully other organisations in the community who have a view about this can engage in that response as well. And you should also, I believe, expect a whole of government response to this. This is a key question for you as a country to resolve, and I would expect that level of engagement, and I hope that you can get that. The second thing is that I think it is important to argue that the principles that are set in this case reflect experiences learned from other jurisdictions and take account of the community and movement-wide input. So it would be useful to not just, it would be useful to encourage the court to reflect on what's been learned from elsewhere when drafting these principles, because there's been a lot of lessons learned in the painful process towards pay equity everywhere around the world. The third thing I think is really important, and I don't know if I can say this loud enough, is this. The focus must be on, in my view, establishing and delivering pay equity, including establishing a pay equity rate. Rates set via this process cannot and should never be based on comparators that are already undervalued or have been discounted because of budgetary issues. If we're going to argue for a rate that we say delivers pay equity to a group of workers or across a group of workers or across a sector or across an economy, let's be certain that the rate we're arguing for is actually the pay equity rate, and not some notion of what we think we might ask for because it doesn't look like too much or a compromise position. In my view, this is not the time for compromise. You compromise in bargaining and negotiation, and that's absolutely fine, and there's a context around that, and that's fine. But when we're standing before the court saying this is what these workers are worth, this is what their worth is in terms of the work that they do, let's be certain that we do not discount that. And I say that so loudly and so strongly because that has been the history of the valuing of women's work. That even when people have said that they've been fighting for pay equity in the past, in many instances, it's been a discounted rate automatically within the context of the system that they're working with, in the context of what they think is achievable, and reasonable. And that's not what we're looking for here. We're looking for what the pay equity rate is. Arguments about the capacity to pay that rate, or whether or not it should be phased in, or over what period of time it should be available to people, come after the rate's been determined, not before the rate's been determined. So those compromise, and it's really, I say this because it's such a strong draw to start discounting. And I can say this from my own experience. When I said in the Queensland Social and Community Services case that what we will be going for is between 19 and 41% increases in wages, people told me I was insane. Some people who know me well might say that was right regardless, but they did. That was a moment within the union office where I said, look, these are the rates, and I said, and next to the rates was a kind of column that said at the different levels what the percentage increase was, and there was a stunned silence because that just looked so far away from reality. Particularly when you say, well, what the pay equity rate for those workers actually is 41%. They are 41% behind where they should be. People just couldn't comprehend an argument that was going to be successful. But it was. So I think it's incredibly important to have the courage around that point. So if we come to this point about the question for you, what do these principles look like? We can talk about principles and you go, okay, what does it actually look like on the page? Well, if you'd like to look at the Australian experience is a really checkered and mottled one around pay equity. Our federal jurisdiction, our Federal Industrial Relations Commission in its various forms, has never dealt well with pay equity. It's had the jurisdiction has been described differently over time. There's been various legislative amendments, but it's never dealt well with pay equity because it's always been dominated by men and men's work. And union officials who are predominantly men who argued. And so just this concept of gender pay equity has never been dealt with well, including, I must say, although Peter doesn't always like to accept this from me, the federal case around pay equity for social and community services workers, which actually delivered flowed the Queensland rates nationally to community sectors is not a great decision on pay equity at all. What happened in the federal case is the Industrial Relations Commission considered a number of things and set up a number of principles, set a number of things, but it did a number, and in the end it flowed the substantial wage increases to the workers, but it did that because it was pressured to do that, because the principles had been established in Queensland and those rates had been established in Queensland. Unfortunately, at our federal level, the Commission refused to adopt and take the invitation to set a number of principles that could be broadly applied. So the Australian federal system still requires a case-by-case analysis, and if I was to say anything to you, I'd recommend trying to get around that as quickly as you can. It rejected the use of the concept of indicators of undervaluation, which had been established in Queensland and New South Wales. And it said that the appropriate approach was to identify the extent to which gender had inhibited wages growth in the industry. So what the Commission said was, I want you to actually tell me what percentage of these rates has been hindered by gender, or how much has gender influenced these rates. I mean, how are you ever going to measure that? So I'm always cautionary when people say it's the federal community sector case in Australia is a kind of real model, because in fact it didn't do a lot of things that are really useful for you on principle, but what it did do at least was endorse the rates of pay that had been set in Queensland. So if you're looking for principles, I encourage you to go to the Queensland Industrial Relations Commission decision, not only because I was the advocate for that, but because it actually set out how you go through this process. And also importantly, the Queensland Industrial Relations Commission had established an equal remuneration principle. And for my mind, I would recommend that being your starting point for where you look at to what these principles might look like on a page. Because the Queensland jurisdiction had gone through the history of equal remuneration and pay equity around the world and how different models applied, and then the Queensland Commission said, well, we'll take all that experience and we'll set these principles in this way. It said when the Queensland Industrial Relations Commission adopted their equal remuneration principle, it said the purpose of the principle is to provide a mechanism for the gender neutral assessment of the value of the work. It retains the traditional elements used in assessing work value. So it said, yes, we retain that concept of those traditional elements of looking at the nature of the work, the skills and responsibility and the conditions under which work is performed, but importantly it added other elements. It said to these, another element is added, other relevant work features. Is that 4 words? 4 incredibly important words that said other things can be taken into account. This element allows consideration of such matters as the performance of unpaid overtime or accessing skill development in the employee's own time and at their own expense, and many other things that could be taken into account when looking at assessing whether equal remuneration had been delivered. It said consideration is able to be given to such matters as the history of wage setting, whether the work has been characterised as female, as well as a range of other indicators that are included in an undervaluation profile. Now, this was critically important. Is critically important, I think, in the Queensland jurisdiction as something worth thinking about. Factors, or a majority of those factors, are in play. Then it's sound to conclude that the work is likely to be undervalued. So contrary to what the Federal Commission said was prove to me scientifically how much of this is based on gender, what the Queensland jurisdiction said was, well, once you've got all these things lining up, these kind of historical, these criteria, it's easy for us to conclude that yes, it's likely that work would be undervalued, and then we look at that, and then we look at how we would fix that. 4 questions, it said, were key in looking at how you would apply an equal enumeration principle or a pay equity principle. What is the nature of the work being performed? Has the work been undervalued? Why has it been undervalued? What is the extent of the undervaluation, and what needs to be done to correct the undervaluation? So the language is very much in that area about undervaluation. Your language, as I read it in your Act, is about differentiation, but the full court, is that what I say? The full court decision does talk about undervaluation. I love that, and that's because Peter introduced that concept in the case below. So it does talk about undervaluation, which I think is a really, really good concept. Importantly, your Act talks about differentiation, and it doesn't talk about discrimination. So I've already heard language around discrimination here. People were discriminated against, therefore they were being underpaid. You need to remove the language of discrimination from this discussion, because that only leads to people presuming that you've got to prove discrimination before you can prove the undervaluation, and that's not the case, because that just leads you down. Was it direct discrimination? Was it indirect discrimination? You're in kind of minefield of those sorts of things. You don't have to demonstrate discrimination, but you do have to look at undervaluation. So what kind of things... So just to finally go to the Queensland decision, importantly, in the Queensland decision, the Industrial Relations Commission found that the factors that had contributed to undervaluation were the origins of the community services sector in terms of its evolution from charity, and that idea that it was charitable work. I'm saying these things because it's very analogous to the case here. The cultural devaluation of care work as women's work. Industry features such that the industry was female dominated, there were few union members, there was a large number of casuals, there was deprivation of training and development and career paths. Industrial issues, including the way wages had historically been set and bargained in the area, or not bargained in this case. And a critical issue that was dealt with in the Queensland decision, which I think is in play here, is the impact of government funding and the gendered view of government policy in this area, i.e. that they accept this concept of it being charitable work and care work being not as important, and their funding models derive that quite considerably. Okay, so, and as I said, that we did achieve wage increases that were between 19 and 41%, and in Queensland case, they were phased in over 4 years. In the federal case, the phasing was over 8 years. So that's another reason why we don't like the federal case.
2 years.
Yeah, 2 years. So, okay, so where does that sit us? So the Terra Nova Forecourt invited or required now the issue of principles to be set. So what might they look like? I said that you'd be the one that went over tone. It's absolutely always me. Okay, from my point of view, and I offer these as suggestions. This is not sort of imposing, but just suggestions, so you don't necessarily have to start with a blank page. The first thing, what would the principles potentially look like? Well, principle number 1, in assessing the value of work, the court or the tribunal or the parties should be required to examine the nature of the work, skills and responsibility required, and the conditions under which work is performed, as well as other relevant work features. So I would encourage you to fight, it seems like a Monty, that first principle, but significantly, that other relevant work features, I think, is an important principle to try and establish. The second principle, principle number 2, that the assessment needs to be transparent, objective, non-discriminatory and free of assumptions based on gender. You might think that that's not required to be said in a set of pay equity principles, but I think you should put it in to the principles that the court should adopt. The third is the purpose of the assessment is to ascertain the current value of the work. Changes in work value do not have to be demonstrated. Now this is one because the employers always run up this thing that says, well, unless we can actually show that people are doing more or different, then really there's no sort of case. And you go, well, actually no, we're not really working from a case. We're working from the place that this work has never been appropriately valued. Full stop. Principle number 4. Prior work value assessments or the application of previous job evaluation processes cannot be assumed to have been free of assumptions based on gender. Okay, so rocking up and saying, but we've had a job evaluation process and the job evaluation puts these positions in this way, is not going to get you out of the question about whether that's been an equitable process. And in fact, we know that generally job evaluation processes have historically been gendered and do not value women's skills in the same way. Systemic factors, principle number 5, that's that systemic factors should be addressed. So that question of how has this work historically been valued should be addressed in assessing whether or not pay equity has been achieved. And there's a whole set of criteria that you can set out there, including whether the work has historically been labelled as a female, whether there's remuneration in the industry or occupation has been undervalued or as a result of occupational segregation or those sorts of things. But that whole idea as a principle that what you will do is do a systemic factorial analysis of the work is important. Principle number 6, gender discrimination is not required to be shown to establish undervaluation of the work. So putting it up front, you don't have to show there's been gender discrimination to actually show that there's been undervaluation. Principle number 7, the comparators within and between occupations and industries are relevant in ascertaining appropriate remuneration. That is to establish the remedy. The proper basis for comparison is not restricted to the same or similar work or work in the same employer or industry. The courts established that principle, but it's worthwhile restating in case people don't actually get that, setting it out clearly. Principle number 7 or 8, where the principle has been satisfied, an assessment will be made as to how equal remuneration or equal pay in your term is to be achieved. Outcomes may include, but are not to be limited to, the reclassification of work, the establishment of new career paths, changes to incremental scales, wage increases, the establishment of new allowances, and the reassessment of definitions and descriptors of work to properly reflect the value of work. So there, what you'd be doing if you adopt that principle is encouraging the court to say that there's not one way of fixing this problem. There could be a range of ways that you could fix this problem, and you can be innovative about the application of that. An important principle, but again another obvious one, would be to say that pay equity or equal remuneration in our language will not be achieved by reducing current wages or other conditions of employment. Okay? No one goes down to achieve pay equity. Okay, so you're all being badly paid.